have another cigarette. Well, thanks a lot, Tom, for being on Neighborhood Conversation. This has been Neighborhood Conversation with Tom Taylor.
Could all the people that are over on the side there try to sit down? There's some chairs still in the back and there's some scattered around. I'd like to welcome everybody to the meeting today, and I'd just like to thank all of the groups and individuals that worked to put it together. And just a list of the groups that have sponsored this meeting is pretty impressive. They include the Student Coalition Against Racism, the Black Cultural Affairs Board, the Chicano Student Union, United Indian Students in Higher Education, the Associated Students at Portland State University, the Young Socialist Alliance, and the Philosophy Department. And as well, the School of Social Work and the Black Studies program were helpful in our attempts to get speakers' fees for Dennis. And special thanks go to the Black Cultural Affairs Board and the Chicano Student Union, who volunteered funds so that we could reserve this ballroom. Okay, before we begin the program, I just want to say a couple things. Just as events that happen 1,500 miles away in South Dakota affect what happens here in Portland and what we do in Portland with extradition, it's also true that events that happen 3,000 miles away in Boston affect us. And conversely, what we do here has an effect both in South Dakota and in Boston. Racist forces in this country have chosen Boston as their battleground. There, they are attempting to roll back the gains blacks have made over the past 20 years by forcing a halt to the school desegregation plan ordered in 1974 by federal Judge W. Arthur Garrity. Through both the use of legal suits and extra-legal racist terror, opponents of black rights have attempted
Thank you very much. Thank you very much. That's the kind of resolutions, and that's the way I like to see resolutions adopted. Yeah. All democratic. We have before here on my right here, first of all, I would like to introduce him as Ron Williams. He is heading my committee to have extradition denied back to South Dakota. Ron Williams. Sitting next to him is the man about states, the man about town, Jack Scott. And, first. And sitting at the controls is, I don't know. In 1789, the Congress of the United States adopted its first official policy regarding Indian people and Indian tribes, and it became a policy for many, many years. I'd like to read that first official policy, which began, "The utmost good faith shall always be observed towards the Indians. Their land and property shall never be taken from them without their consent, and in their property, rights, and liberty, they shall never be invaded or disturbed. That was the first official policy of the United States Congress. It has changed throughout the years. And in 1857, when reservations became established and Indian people began to be confined to them, the policy then read by the Commissioner of Indian Affairs in 1857, reservations should be restricted so as to contain only sufficient land to afford them a comfortable support by actual cultivation, and should be properly divided and assigned to them, with the obligation to remain upon and cultivate the same. This, of course, was the enforced acculturation policy. And then in 1862, Secretary of the Interior Caleb B. Smith said, "The rapid progress of civilization upon this continent will not permit the lands which are required for cultivation to be surrendered to savage tribes for hunting." And then in 1889, a year before the Wounded Knee Massacre, the Commissioner of Indian Affairs, Morgan, "The Indian must be absorbed, not as an Indian, but as an American, and he has to be individualized. The tribes and traditions are to be destroyed. The Indian nation would have to conform to the white man's way, peaceably if they will, forcibly if they must." That was the policy to 1889, which, of course, many of you history students who have been following the conditions and patterns of U.S. policy know that many Indian people have lost their lives throughout the great wars on the frontier between Indian nations and the U.S. government. Finally, after an 8.5-month trial in 1974 in St. Paul, Minnesota, the prosecution for the United States government, in summing up the case against Dennis Banks and Russell Means, speaking to the jury, "I don't care about the 1868 treaty, and I don't care if the conditions on the Pine Ridge Reservation are good or bad. I submit to you, ladies and gentlemen of the jury, that I don't care." Unfortunately for the government, the case was dismissed because of governmental misconduct. But I think what it outlines is that the policy of the government, whether it's been in Interior Affairs, whether it's been in the Bureau of Indian Affairs, or whether it's been in courts, the attitude and the behavior has been the same, that they don't care. They don't care about the conditions that Indian people face, whether they're off the reservation or whether they're on the reservation. There are three things that I have asked non-Indians to follow up on whenever I talk to them and whenever I leave them. Three things that we are asking across this country. These are suggestions that have not been advanced not only by the American Indian Movement, but by other Indian organizations as well. They've been demanded by Indian tribes, and in this area, in Oregon, and parts of the Northwest, and in California, where the federal government has terminated the trust responsibility between the tribes and the governments. They have asked these ones already. Number one is that a treaty commission be established by Congress to examine 371 treaties and to begin an enforcement policy that would permit the many rights, the Native American rights, the treaty rights and civil rights and human rights to be honored and to be upheld. The treaty rights which are asking for the protection of natural resources. These are very important because now we see a more aggressive move by Interior to move on to Indian reservations and in some area remove Indian people again, such as the Northern Cheyenne in Montana, to strip mine the reservation. Number two, to remove the Bureau of Indian Affairs from the Department of Interior because of the tremendous conflict of interest, because of the conflict of responsibility. The decisions about Indian lands, about Indian rights, water rights, coal, and other minerals are not made by Indian people. They're not made by the BIA, but they're made by Interior Department. And Interior Department, we all know, is controlled by the corporate interests in the United States, such as Westmoreland Industries, Kennecott Copper, Standard Oil, and Phillips 66. These are the big corporations that control Interior Department, and Interior, unfortunately, controls the Bureau of Indian Affairs. And number 3 would be to amend the 1934 Indian Reorganization Act to allow for a revision in that act so that we will never again see one man become a dictator on these reservations, such as happened on the Pine Ridge Reservation in 1972 and 1973. In 1972, a man by the name of Richard Wilson became president of that tribe, and soon thereafter, the kind of corruption and the kind of graft that we see in some governments, we also began to see on the reservation. But it's this kind of corruption, the kind of corruption that led to outright murder. And since May 8th, 1973, there have been 241 violent deaths. 41 of these have been outright murders of Indian people with virtually no investigation. All of these murders have been unsolved as of this date. And even 2 weeks ago, the United States Commission on Civil Rights criticized the FBI in the investigation of Annie Mae Aquash, who was arrested with my wife here in Oregon so many months back. She was a co-defendant. She was scheduled to go to trial May 12th, but they found her, and the death certificate said death by exposure. And yet when we found out, and the gruesome way of how they made identification, they chopped her hands off and sent her hands to Washington, D.C. for identification. And finally they sent it back they said that this person is Annie Mae Aquash. And because of the identification, because of her being very, very close to both Kamuk and myself, our attorneys, the attorneys for the Wounded Knee Defense Committee and the attorneys for the family of Annie Mae Aquash, applied for the body to be exhumed and an independent autopsy performed. And a coroner from Minneapolis went out there and conducted the autopsy. And even when they had the body exhumed, FBI agents who had initialed the initial death certificate, that she had died of exposure, ran forward and opened up the casket and put it in a little plastic bag. And the plastic bag was Annie Mae's hands. After the autopsy, the coroner said, she didn't die of exposure. There's a bullet inside of her head. The bullet inside of her head, of course, is the kind of death. It is commonplace now. We're no longer shocked when Indian people are found murdered alongside the road. It is not shocking anymore. And that's the whole irony of living on the reservation, is that when you see that kind of terror and when you see those kinds of conditions coming down every day, it is no longer shocking. It should someday perhaps we might see a movement of people who are concerned about the senators and congressmen who control the Interior and Insular Affairs Committee. Perhaps we could see people move those senators, to action so that they might do something, get them off their rear ends. That basically is what is going on in Indian affairs. Is there's been inaction, massive inaction, and that has allowed to go on so darn long that people virtually don't even care anymore. Those three things I would like to see happen even as we leave here today. The Treaty Commission, the amending of the 1934 Indian Reorganization Act, and the removal of the BIA from the Interior Department. Those three things you must remember. I would like to first of all explain a little about the case. I'm involved certainly in two cases. I cannot speak again or about the case coming up May 12th, but I can speak a little about what happened in South Dakota and why I'm fighting extradition. I'm fighting on basically 3 points. To have you sign petitions, and if you haven't signed a petition, perhaps after I explain to you, you might want to lend your name to those petitions. Number one has been the direct and the indirect threats against my life. Number two, there are the unfairness of the trial in Custer, South Dakota. And number three goes to the violation of the 8th Amendment of the United States Constitution, which says that no person should be subjected to cruel and unusual treatment. And the South Dakota prison system is now under attack by the U.S. Commission on Civil Rights and also by the Native American Rights Fund in Boulder, Colorado, because it is discriminatory in nature and because it offers no medical facilities or any medical care for the prisoners there. So those 3 points. Number one, going back to the trial itself, which was one of the most incredible travesties of justice that I've ever seen. I'm also a tribal attorney on the Rosebud Sioux Reservation. I'm an attorney for the Rosebud Sioux Tribal Court. I'm not the kind of attorney that you are used to knowing about. I haven't attended any law school, but I'm familiar with the Constitution and the bylaws of the Rosebud Sioux Reservation. I also have taken a pledge to uphold those laws on the reservation and uphold the laws of various laws of the United States Constitution. On January 21st, 1973, Darrell Schmidt, a white person, walked into a bar in Buffalo Gap, South Dakota. And before 6 eyewitnesses, he announced that he was going to kill an Indian. And when the night was over, Wesley Badhart Bull was dead. He was stabbed in the heart. Because of the eyewitnesses, we felt that, and everybody there felt that some arrest should have taken place that evening, but there was none. And so the mother called us. We called our attorney, Ramon Rubidoux in Rapid City, who went down there and conducted a 3-day investigation and collected all this and turned it over to the commissioners, and they in turn ordered the sheriff of that county, Ernie Pepin, to arrest Darrell Schmidt, and he did. And the county attorney charged him with second-degree manslaughter, which is, if convicted, he could receive 10 to 15 years. And we felt because of the premeditation involved that it should have been murder. And so we called for a meeting on February 6, 1973, and they agreed that such a meeting should take place. And part of our reasons also were to establish a Human Rights Commission in Custer, and the clergy and the local citizens of that town agreed that we would do such, we would create such an agency. But when we got there, the meeting had been called off by law enforcement. And there are 2 courthouses in Custer. There's the old courthouse, where we were meeting, and then the new one across the street. The old one had been condemned and had been boarded up, and they reopened it, and they fired up the old burners again, and that's where we were going to meet. And we were meeting inside, or they'd called off the meeting, and Russell Means, Crow Dog, Dave Hill, and myself went inside to see why the meeting had been called off, and hopefully to establish a new one. And they a fight broke out on the outside between Sarah Bathart Bull, the mother of Wesley, and a state trooper. And instantly there was a riot going on. And those of us meeting in that room tried to get out, but the tear gas was thrown upon us, and the door was slammed shut. And we tried to, get out. We tried to open the windows. We couldn't do it. And I finally grabbed this nightstick, and I began to smash the windows out. And all of us, including the county attorney, and I had our heads out the window grasping for fresh air. The newsmen had been covering this, took pictures of this, and after the 2.5 hours of riot, 23 Indian people had been arrested, and 6 Indian people were in the hospital, and blood had flown from both sides. They didn't arrest me, even though I stood right there, trying my best to stop, the attacks upon the Indian people, particularly the women. They were being drugged from one end of Custer to the other end. Clubs were being used on them, and I stood there hollering and screaming and trying to prevent this and that. And they arrested me the next day, though. They charged me with injury to a public building and arson. And Sarah Bathart Bull was charged with arson and riot. And then, of course, the Wounded Knee siege began on February 27th. And in late 1973, Darrell Schmidt went on trial in Rapid City, South Dakota, and was found not guilty of second-degree manslaughter. A number of things happened in 1973. First of all, the court, in response to our motion to have a change of venue, conducted a survey where they interviewed 1,200 prospective jurors in South Dakota. And after the survey, the federal judge by the name of Fred Nichols moved the case to Minnesota because of community bias, actual bias, and particularly against the American Indian movement and its leaders. And there were 5 different surveys conducted in South Dakota. And then the trial was moved to Minnesota, where after 8.5 months, it ended in Judge Nichols dismissing it for governmental misconduct. During 1974, Sarah Bathart Bull went to trial in Sioux Falls, South Dakota, and she was found guilty by an all-white jury, and she was sentenced to prison, and she is now out on an appeal. Vernon Belcourt, who was facing arrest out of the Custer incident, went to trial also in Sioux Falls, and after going through a record 107 people, the judge by the name of Judge Braithwaite dismissed the charges against him because of the large community bias against the American Indian movement, and he based partially his decision on the Wounded Knee decision. But he had more information. He conducted his own survey through the voir dire process, and the charges were dismissed against Vernon Belcourt. And finally, in 1975, I went to trial in July. Going back to October of 1974, as a tribal attorney for the Rosebud Sioux Court, we investigated a crime on that reservation, and a 15-year-old Indian girl had testified that she'd been raped by a white man, and that this information was turned over to the U.S. Attorney's Office, who refused to prosecute. So we then prosecuted on the lesser charge of assault with intent to commit rape and carnal knowledge with a female under 16. After the trial, the tribal judge by the name of Judge Gonzalez found probable cause that 2 offenses had been committed. One was the assault with intent to commit rape, and the other carnal knowledge, and he issued 2 warrants, which are outstanding today, for the arrest and apprehension of this man. The man's name is William Janklow. On the very next day, November 1st, 1974, William Janklow was elected to the position of Attorney General for the state of South Dakota. He vowed then, publicly and privately, that he would do his best to destroy myself and the American Indian movement. And then the trial itself. You have to understand Custer, South Dakota. Custer is a small town in the western part of South Dakota. It sits within the original boundaries of the 1868 Sioux Treaty. It's in the Black Hills, which is still property of the Oglala Sioux Nation. The population of Custer runs about 2,200 in the wintertime and reaches perhaps 4,000, 4,500 people during the summer because of the tourist industry. And on the day before the trial began, the local bar association passed a resolution which excluded me from use of the law library. They said if I wanted to use it, I could use one in Pierre, which was 200 miles away. Then that was the first one. When I saw that resolution, I knew it was going to be a long day in court. That was the first incident. The second incident, of course, was the jury selection. They brought them up in panels of 50 people each. Had 50 people in the courtroom, 50 people in the basement. And after the preliminary questions of dismissing people who are elected, firemen, police officers, and commissioners, and whatever, people who are sick and can't serve on a jury, the first question that we asked the jury was, do you think that Dennis Banks is guilty even before we go to trial? And they all raised their hands, and we did dismiss them. And then they brought up the next 50, and again the same procedures and same questions. And do you think Dennis Banks is guilty now even before we go to trial? If you do, raise your hand. And everybody raised their hands, and we dismissed them. That process took 2 hours. And so the next day, when we reached 107 people, which was in the Judge Braithwaite decision, we moved for dismissal, and the motion was denied. And we kept on the question of voir dire. And when we went through 214 people, we again filed another motion to dismiss, and that was denied. And then when we went through 328, a record number of people in the state of South Dakota, since they've been a state in its entire life, we went through more people in that single trial. And again, the judge dismissed it. He denied the motion for dismissal. And he said, we're going to find a trial here. We're going to find a jury if it takes us all year. And they proceeded to find one. And, you know, they were running out of people at that time. And to tell you how far they were running out of people, this one man didn't answer the roll call when they called in the next 50 people. And the judge, of course, became very furious. He became very mad. He says, I want these people to show up for jury duty. He says, we've got to find a jury. And he says, I want a bench warrant issued for this man right now, and go out and get him. And so the sheriff went out, and he came back in the afternoon, mid-afternoon, and he said, I'm sorry, Your Honor. He said, this man has been dead for 3 years. Then they began to bring him in wheelchairs and stuff like that. So, and the lady who did come in a wheelchair, she just come in halfway into the well, not even into the total court at all. She took one look at me and she says, he's guilty, and turned right around, went on out. But we stayed there. We found 14 people in that town, and we went through 7 panels of 50 people each, and we'd secured the final number from the people in the courtroom, and underneath was the 8th panel, sitting in the basement. And one person who was in that 8th panel, who could have, in theory, sat on my jury, was Darrell Schmidt. So they were going all out to try and find a jury, and we finally went to trial, and they appointed 2 two attorneys to defend me because I said I was going to go pro se. I didn't trust the attorneys in South Dakota. I wanted to be my own attorney. And they appointed two of them, and one of them kept resisting orders that I gave him. He kept being late on, when we asked him to Xerox stuff and take it before the judge, he was always late, and he was causing delays, and you know, I was getting very upset because our defense wasn't looking very good because of his actions. And finally, you know, every morning I would get up and I'd say, these people are not representing my interests. And finally, after 2 weeks, the judge dismissed them. And that very night, I received a phone call from Dan Jackson, who was the attorney that kept causing the delays. And I asked him, you know, what he wanted to talk about, and he says, Dennis, he says, I want to talk to you. He says, but meet me at this place here. And he told me, he gave me the directions. It was 5 miles outside of Custer in the western part. And when we got there, it was we both parked our cars there, and we went in a cornfield. And you know, here there's no one else around. But here we are at 9 o'clock at night, two grown men, you know, standing in a cornfield. And he told me, he says, Dennis, the reason why I didn't defend you properly and the way I should have was because I was threatened by the Attorney General. And I asked him if he would testify for me the next day, and he said he would. So the next day we went, I asked the court to interrupt for this witness, and we went into chambers, you know, outside of the presence of the jury, and where he admitted, or on the stand again, and the judge this time asked him the questions, and he admitted what he told me there. And then they asked the Attorney General, William Janklow, if that was true. And he says, well, yes, I did in fact call him, and it's true that I used those words, you know, to get him. And the judge asked him what he meant by that, and he says, well, he says it's just a political statement. And so that was part of. All of this went into my records, of course, for, you know, to have a motion dismissed on prosecutorial misconduct. But then the judge said no. He said, what this man's testimony is not relevant and that the jury should not hear this man's testimony. So we could not get that in front of the jury. And looking back, not that it would have made that much difference, but I'm sure that, you know, that maybe one of them might have held on to some kind of decency in arriving at a decision. But that was another point, and